Hi everyone, and welcome back to our second micro lecture of the module and the final one for the whole semester. In this micro lecture, we're going to discuss drug courts and how these specialized courts are working to help low-level, first-time drug defendants deal with the root of their problem rather than criminalizing the addiction. Let's go ahead and get started with our last discussion of the term. I know we briefly discussed drug courts earlier in the semester, but I thought it would be best to start this discussion at the beginning. First, what exactly is a drug court? This is a type of specialized court whose docket processes specific defendants who may be facing drug-related charges, juvenile offenders who already have a drug offense, but as a minor, or any adults who have dependency issues that are interfering with child welfare cases. You can think of this as more of a diversionary type of program that specifically applies to those individuals with drug issues. This doesn't apply to drug traffickers or suppliers or those with multiple prior convictions for drug-related offenses. Instead, drug courts are specifically designed around the following components. First, there is screening based on assessment of risk, needs, and responsivity of the individual. Second, the individual's history of judicial interaction, meaning that they are a first-time defendant or that they don't have any priors. Drug courts also use monitoring, i.e. testing, and supervision to make sure that the individual is complying with the drug court program requirements. Drug courts also implement graduated sanctions and incentives. This suggests that the penalties are significantly lesser for those individuals who comply with the program and don't continue to use illegal substances. Finally, these programs are built around the idea of treatment and rehabilitation services, so the defendant can get clean and sober without criminalizing the addiction. Drug courts are usually managed by a non-adversarial and multidisciplinary team, including judges, prosecutors, defense attorneys, community corrections, social workers, and treatment service professionals. In other words, it takes a team of professionals who recognize that substance abuse is a complex issue. Support from stakeholders representing law enforcement, the family, and the community is encouraged through participation in hearings, programming, and events like graduation. As we discussed in our War on Drugs lecture, in the 1980s, there was a massive explosion of drug convictions related to illegal substances, which alongside mandatory minimum sentencing, substantially increased the prison populations at the state and federal levels. This tough on crime movement can still be seen today as we continue to feel the ramifications of those legislative efforts. Ironically, at the same time, we saw a counter movement also emerging when it came to drug courts, which were some of the most innovative court structures at the time. Today, we see a variety of specialized courts exist as it pertains to veterans, teenagers, families, and more. But all of those specialized courts have grown and were developed using the tenet principles derived from drug courts. One of the issues we saw at the time was the number of the revolving door drug offenders. Specifically, the overwhelming number of drug offenders were burdening the system at every stage from arrest all the way through reentry services. Although drug offenders were being arrested and convicted, they would eventually be released and simply return to the system because their needs were not being met with the traditional structure of the criminal courts. Community-based programs were having better luck treating the symptoms of drug addiction rather than just criminalizing the addiction itself. But once those resources became strained, a new approach was needed. Enter drug courts. As their name suggests, drug courts handle only defendants with felony or misdemeanor drug cases, usually non-violent defendants with substance abuse disorders. The argument for segregating drug crimes from other offenses is threefold. First, judges, state's attorneys, and public defenders who specialize in drug cases become more proficient and efficient in all aspects of case processing. They improve at screening cases, using case information, presenting motions, submitting guilty pleas, and filing case dispositions. Typically, defense attorneys and other actors will specialize in targeted clients because they know the most about the specific area. Just like you would visit a heart surgeon to perform your coronary bypass, you want the best in your specific area of need, and drug courts are no different. With focused practice, they can complete court tasks and resolve problematic cases more quickly and effectively while keeping the best interest of the defendant and the community in general in mind. Because remember, worst case scenario, if the defendant fails to comply with the requirements of the drug court program, they will be diverted back to the traditional criminal justice system and will be processed like any other defendant. Second, when being processed through the traditional CJ system, drug defendants must wait their turn to appear before a judge and to have their case heard. As drug courts only focus on drug defendants, it takes less time for an individual to be processed. In the traditional structures, drug cases are less of a priority in comparison to more violent offenders, where time is more of a concern. In specialized drug courts, drug offenses are the court's first and only priority, an approach that precludes inordinate delays and generates more successful prosecutions and convictions of drug offenders. Finally, the development of evidence as it relates to drug cases is typically more absolute than in other cases. Individuals might be found in possession, are caught during a sale, or reliable witnesses are available to corroborate law enforcement accounts. These typically would be settled through a plea bargain anyway, so the drug courts know what will happen almost before it does. There is typically a standard sentence for these types of cases, so there is less negotiating room for the defendant. Some research suggests that in addition to saving time for the court, it also helps to produce equity among the defendants, therefore lowering sentencing disparities based on race like those that we have seen in traditional court structures. As I mentioned in my previous discussion of drug courts, there was a movement that came out of the Miami-Dade area in Florida in 1989, where an explosion of cocaine use occurred at the time. As Miami was a port city, the importation of cocaine was difficult to stop, and the availability of illicit substances was robust in nature. The efforts of the war on drugs were not enough at the time, and with an administrative order from the Chief Justice of Florida's 11th Judicial Circuit, the first drug court in the United States was born. The Miami-Dade model was the first of its kind, but it certainly wasn't the last. As I mentioned a slide or two ago, the judge and a team of CJ officials worked together in tandem to find a solution that is best for the defendant to help this individual become clean and sober, while still holding them accountable for their crime. The team works together to monitor the defendant and to help treat the root of the drug problem. If there are specific issues that the defendant is dealing with, perhaps unemployment issues, domestic violence experiences, child welfare cases, homelessness, etc., then the court will take that into account when helping the defendant work through their case. More than 30 years later, this style of specialized court makes sense and has been adapted throughout the country. But at the time, this was widely controversial and went against everything that was being promoted through the war on drugs. However, it did catch on and is now a staple in many states across the country, including Texas. To date, there are more than 4,000 drug court programs which serve adult defendants in the U.S. Additionally, of that 4,000, there are roughly 9% that exclusively serve juvenile defendants, while still allowing them to remain in the juvenile system. On Canvas, I have linked a resource which allows you to have an interactive look at all of the locations of specialized drug courts in the U.S. and the types of clients that they serve. In 1994, the Clinton administration passed sweeping legislative reforms known as the Crime Bill, which really clamped down on mandatory minimum sentencing and continued the proliferation of mass incarceration, specifically as it related to drug offenders. We know now that President Clinton regrets his involvement in the passage of that bill, but what we haven't discussed yet is the provision built into that bill that further provided funding for drug courts. Yes, that's right. At a time when the U.S. was really locking down on drug offenders, we see a dichotomy taking place in which funding is being provided for the establishment of additional drug courts throughout the U.S. and for the continued financial support of those already in existence. Additionally, in this bill, specific funding was earmarked to provide research and evaluation studies of drug courts to ensure that they were meeting the desired outcomes and effects on the program. In other words, are the drug courts effective in treating the symptoms of addiction rather than just criminalizing them? The NIJ would be responsible for conducting those evaluations and making these assessments. Around the same time, we saw the first ever National Drug Court Conference take place in the Miami area, where more than 400 judges, prosecutors, defense attorneys, and drug treatment specialists come together to design a set of bylaws of sorts that establish what the fundamental core principles of a drug court should include. We have already discussed them somewhat, as they include the notion that drug courts would only process drug cases, that all judicial actors would be specialized in this field, that mandatory training would continue for all actors throughout the years. Think of this as almost continued education. And that this would be a multifaceted approach to treating substance abuse and addiction as an illness to be treated rather than to be criminalized. Although the idea of drug courts was favorable in the beginning, initial evaluations were not as promising as we had hoped. Evaluations conducted in Philadelphia, Milwaukee, Los Angeles, and Detroit all showed that the processing time for drug defendants was significantly lower than for those individuals processed through the traditional course. However, that processing came at a cost. Drug courts in those cities were associated with less effective use of resources, more lenient sentences, which was sort of the point, but okay, and higher operational costs. The big one, though, was that drug courts did not seem to have an effect on the decreased arrest rates of drug offenders. When it came to even larger markets like Cook County and Chicago, the results were even worse. Given how large the Chicago area is, reports were coming out that the caseloads were overwhelming to manage and that defendants were not successfully completing the programs as resources were spread much too thin. In order to combat this growing crisis, Chicago basically began running drug courts 24/7, with night court being implemented to handle the overflow that came from the daytime courts. This meant the hiring of a whole second set of judicial actors who played a vital role in lessening the burden of the day staff. With night court established, we finally started seeing the results that we were after. Drug cases were taking less and less time to process. The percentage of prison sentences were declining as the success rate of the program completion increased significantly. The downside of night court was the burden placed on the judicial actors. They were tired, still overburdened, and rushed to get through the backlog of cases that resulted from the day court slowdown. The phrase assembly line justice was implied more than once, suggesting that although they were being efficient in processing, was the quality of justice suffering as a result? Could there be a better way? Enter the second generation of drug courts. We tried something, and while it had great intentions, we might need to make some improvements. The second generation of specialized drug courts, and the most prominent, are the more service-oriented than their predecessors, which were aimed primarily at improving the speed and efficiency of case processing. Although drug courts differ in their structures, operations, and staffing, they are predicated on the assumptions that drug use is deeply rooted in the community and that addiction is as much a public health problem as a criminal justice problem, and that drug treatment is the only long-term solution to the drug crisis. Drug courts were created for persons with substance use disorders who enter the criminal justice system because of a drug defined, meaning the possession of small amounts of drugs, or drug-related offenses, meaning a theft or something similar to obtain money to purchase drugs. As these courts are specialized to a specific group of criminal defendants, the court needed to be just as much client-centered, meaning that they're treating the defendant as a human with specific needs, as much as it was about the statistical success, which was measured in the number of closed cases. Researchers and academics define this style of processing as therapeutic jurisprudence, which suggests that the law has a role in the rehabilitation of the defendant and needs to focus on the defendant's well-being in addition to considering the safety of the general community, that the law can do just as much harm to the individual as it can do good. Returning once again to the Miami model, which quickly worked to incorporate therapeutic jurisprudence, its philosophy and operational design became the prototype for future drug courts. The court is based on the premise that addiction is a disease that promotes criminal behavior. It is therefore highly treatment-oriented and supportive of clients' recovery efforts. Defendants are neither prosecuted nor punished for their substance use problems. Instead, the court provides or brokers drug treatments and other services that help them achieve sobriety and stability in their lives. Defendants do not have to participate in the drug court program, as it is completely voluntary. However, if they decline to participate, then they will be cycled back into the traditional system to wait for their processing. In order to qualify for this style of program, they have to be charged with purchasing or possessing of illicit substances and are automatically disqualified if they are charged with or have a history of violent crime, drug trafficking, or any felony convictions. The court's procedures are non-adversarial. Led by a judge, its operations are conducted by a team that includes defense and prosecution attorneys, as well as other court personnel and treatment providers. The team appreciates the nature of addiction, relapse, and recovery. It participates in a shared decision-making protocol and fosters clients' efforts to remain sober. The judge plays a central role in monitoring participants' progress, encouraging them to remain crime and drug-free, and dispensing sanctions for their failure to comply with program requirements. Throughout the program, judges and clients meet often to ensure that the judge's presence is paramount in the client's lives. The program lasts somewhere between 12 to 18 months, dependent on the court's requirements, and incorporate a behavioral treatment model like we discussed in the first micro lecture. Defendants are required to go through with detoxification, stabilization, and aftercare treatment programs, which help break the defendant of the addiction and help them in their attempts to stay clean and sober. If the defendant can do this and meet any other requirements of the court, the charges are typically dismissed after 12 months. Some courts hold a graduation ceremony of sorts where the charges are expunged from the record and the defendant can walk out head held high that they are changed for the better. The second generation of drug courts established the success that the first generation was lacking by seeing the defendant as more than just a case to be processed, and by providing the court with resources to be able to treat the defendant like a person instead of just a number. Drug courts have had resounding success. Although there are always the exceptions to the rule, in general, most defendants graduate and go on to have successful lives. Many are reunited with their families and children. They find jobs, are no longer homeless, and most importantly, no longer have substance abuse issues. The Miami model has been duplicated more than 4,000 times as it relates specifically to drug defendants and has been expanded to treat other individuals as well. Drug courts have been replicated as veteran courts, DUI or DWI courts, juvenile drug courts, family courts, and more. These specialized courts continue to clear the docket of traditional courts and allow more humanization of the defendants who might be dealing with specific issues. Mental health services, career services, family counseling, drug treatment, and more forms of rehabilitation are made available to these individuals who wouldn't have received these services had they stayed within the traditional court structure. The point of the CJ system is to treat the systemic reasons for why crime occurs in addition to punishing the individual for the crimes that they are guilty of. Of course, critics will always point towards the habitual offenders who continue to commit crimes after their sentences have been served. But with the success of these specialized court structures, there is proof that a one-size-fits-all approach doesn't help everyone, as evidenced by the revolving door offenders who receive next to no services while incarcerated or once they are released. With the proper funding and resources allocated to these programs, there is proof out there that some efforts are successful in changing the culture of the CJ system while still requiring the defendant to be held accountable for their actions. The lock them up and throw away the key culture is not effective in the way that so many tough on crime proponents suggest. All that does is make a desperate group of people even more desperate upon release. Without resources, panic sets in and these people return to the only way of life that they may know. So if the goal of the system is to promote general safety and correct criminal behavior, why don't we continue to try more of what we know works? It makes sense to me if you think about it that way. This concludes our final micro lecture of the semester. I thank you so much for your time and attention throughout our many discussions this term. I hope that you leave this class knowing more about drugs and the criminal justice related issues than when you came to me, and I hope that you keep an open mind about these issues as you move forward throughout the program. As always, I hope you enjoyed yourself, and I hope to see you again in future courses. Thanks everyone, and have a great break.